Come on. Come on.
Put your emojis together for Auntie Miracle B.
Money calling on the line, I couldn't budge still. 420s, I just counted off a drug deal. You ain't a grinder, you got fronted, how your plug feel? Get them in, get them gone, that's how my plug feel. We was sliding on the out, now that's a hit. Keep a blicker when we move, we got them sticks. Red bottoms on the J's, hella sauce in. I was running through a South 10. 01, I was running through the South End. Step it up, son, you talking to a boss man. Flexing out around these bitches, tell them stand down. Earl Spence, that's a man down. We got all the bodies, we got all the shooters. I be with the hitters, we just bought them Rugers. For a plate, and my youngest do it. For a plate, send my youngest do it. Whoa, now, what it is. Had me knocking nigga off with his kids. I'ma run the money up, what it is. Running through the city, wow, this how we live, how we live.
Oh, yeah. Good afternoon, everyone. For those of you guys who don't know, that gentleman there that is rapping that godforsaken awful song is Darrell Who Is You Brooks. Mr. Brooks was just convicted last week of 76 counts of reckless endangerment and killing 6 people. Hey, Cold Brew. So I wanted to give my opinion about the trial of the century. Am I sounding okay? I can't tell. Yeah, who is you? So I want to know how we got to this.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did not.
I didn't have to be provided with. We're going to call this witness at this time,
but they're
this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have to do that?
And accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses.
It's about what's fair. It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this
court. How am I controlling what's happening? I'm the one shackled to the table with a shock device on my
9:52.
So how's I'm trying to control anything? I just want this to be fair, and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to me how that's fair.
The process that has been set up to frankly help you.
No, it's not helping me it's helping the state by being able to say, if we know the time and we know the person and we know this, then we can be prepared. So we'll already be ready.
Mr. Brooks,
that was the whole aim of that.
And I would have had her come in later. You didn't want to answer that question.
There was no question. There was no question to answer. I did what you asked me to do, Your Honor. You said, yes, you did. You did. You asked me to give them my witness list.
Brooks,
I gave them my witness list. It's not my fault. It's not my fault they weren't going to be prepared to
Mr.
do
Brooks,
their
here's the deal.
to do
the
their
jury's
cross.
Coming out, and I'm going to stand my ground on this.
I'm going to stand my ground too, but I'm not going to be disrespectful or disruptive. I'm just stating I want it to be fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that. Where's the lawful law? Where's the lawful law? I have the right to witnesses.
You have to cooperate with this process.
But I also have the the Sixth Amendment right.
We have a witness available for you to call.
Sixth Amendment
I
right.
can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That didn't
in
have
the
a time. That didn't have a time or of
I'm not going to
or an
play
order.
this game with you, sir.
It's not no game.
It
That's what you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We
I don't take
I
this as a
asked-
game. That's what
Let me explain
nobody.
this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
Do you want
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
It is
some
unfair.
gamesmanship
It's
that's going on.
unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
what type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So
I
I
understand.
think, Your Honor, with all due respect, I think you
So
should show
we're
some
going to take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
No, you're not rushing me to judgment. I don't care which, Your Honor.
Oh, Lord, sorry about that. Yes, that is Darrell Brooks, one of his many, 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 many outbursts. If you have not watched this trial, I suggest you go to the Law and Crime Network channel, the other one, Court TV channel, and it has been absolutely insane. I have been riveted to this trial every day. So I was been watching this. I've been really curious. So how did we get to this point? So in order to understand a story completely, we have to go back to the beginning. So if some of you may not be aware, this is the guy who ran his SUV. Let me back that up. This is the gentleman here, the animal who assaulted his ex-girlfriend, punched her in the eye, and slapped her, had a bitch fit, got in his car, drove off because the police were on their way. So he was fleeing from the police. He decides to go drive into a parade, a Christmas parade, and killed 6 people, including children and elderly. He directly ran into this group of people called the Dancing Grannies, and he's injured dozens and dozens and dozens of others to the point where he had 76 charges. 76 charges. So this was back in November 21 of 21. So 76 charges. Okay. So he initially was filed a claim, not a claim, I'm sorry. He initially decided he was going to file and be mental temporary insanity by mental health or defect. But then he decided a week before to fire his attorneys and retract his plea. So he's going to represent himself. And why is he going to represent himself? Because he's a sovereign citizen. And this is the reason behind all of this stupidity that we see on a daily basis in court. So let me pull up the start of the original sin was when he decided that he was going to represent himself. Hey, 504. Hey, everybody. I know I spoke to y'all in the chat, but to everybody who's just coming in, welcome, welcome. Let me see. Okay, here we go. So what we're going to see here is what they call a colloquy. And what that is just to determine whether or not he is competent and he understands by firing his attorneys that he's going to be by himself and doing it all by himself. So we're going to get to watch the word game, okay? And I'm going to try and break down, when we get to relevant portions, his sovereign citizen BS. So with no further ado, this is Judge Darrow. This is the prosecution here, and this is Numbnuts and his 2 attorneys that he's about to fire.
12:30 today, just to go over what I would call some scheduling, housekeeping matters. related to this case and the motion before the court. I don't believe I need to put any of the substance of that on the record unless there is a request from either of the parties.
Hold
I do
on.
not intend to go over any of the substantive.
Hold
the
on.
Right to have,
Okay.
right to have an attorney.
Okay. Hold on.
So you're gonna have to tell me what you think that means.
Hold on.
Proceed in this matter.
Okay, here we go. Here we go.
You, is it your desire to represent yourself in this case?
It is, I would like to proceed in this matter, for prior persona, not pro se.
Say that last part again.
I would like to proceed in this matter in pro per, not pro se.
So you're gonna have to tell me what you think that means.
It is me exercising my right to defend myself, to represent myself as a sovereign citizen.
Okay, so first thing, I went to law school. I have a law degree. I do not remember anything about self-representation that says that you can represent yourself, self-representation as a sovereign citizen. I don't remember any of that in any of my 4 years of law school, period. Okay. So, let me see. So here's some of the beliefs that he holds, and this is important. So as a sovereign citizen, he believes that he's immune from the law, and citizens are in an oppressive contract with the government. And so because of this contract, they try to do anything they can to avoid restrictions, taxes, fines, etc. So they accept a law or regulation that means they've waived their rights as a sovereign citizen, and they've uh, accepted a contract with the government, right? So in order to avoid this, they normally say, I do not consent all the time. You've seen those videos. They say, I do not consent. I don't understand. Because they believe if they say, I understand, it risks them being in a contract or a, as he loves to say, tacit agreement. So knowing this base information, we can continue on and see how this goes.
So essentially, this matter today would be me appearing by special appearance.
You have an absolute right to have an attorney represent you. It is protected not only by the Wisconsin Constitution, but the United States Constitution. Do you understand that?
I do understand my rights under the United States Constitution, yes.
Did you hear what I said?
He is a former meth head.
Do you understand that you have the right
Hey, Bozzy.
to have an attorney represent you, what we call the right to counsel?
Under the Sixth Amendment, correct?
Under the Sixth Amendment, the 14th Amendment, and the Wisconsin Constitution as well. It's a well-established.
What did he do? He killed 6 people and injured dozens more by running his SUV in a Christmas parade, November 21st of 21. And he was just convicted last week after a very interesting and exciting trial. It was the best thing going.
Established right that a criminal defendant has. Do you understand that?
I'm aware, yes.
Do you also understand that you have the right to represent yourself?
I'm aware of that as well.
So you notice she's asking, do you understand? And he responds, I'm aware. Let's continue.
I have before me a motion to withdraw by your attorneys with the sole basis that is listed that you want to represent yourself. Is that your understanding as well?
That isn't entirely how the issue came about. I think it's important for that to be on record.
I'm not asking you to divulge attorney-client privileged information. Do you understand that?
So essentially, what's the question?
Well, I want to make sure you understand you have these competing rights. It is recognized in our case law from the United States Supreme Court, the Wisconsin Supreme Court, that there are these competing rights: the right to counsel and the right to self-representation, essentially to be your own counsel. Do you understand these competing rights?
I am aware.
I am aware.
Do you understand, sir, that you can't have an attorney and exercise that right and also exercise the right of self-representation?
No, I don't understand that.
So you started off this hearing by saying you want to exercise this right to appear in persona today and act as a sovereign citizen. Sir, my concern here today is there's a request from your attorneys to withdraw from this case. Do you understand that's the request before me today?
I'm aware that they filed a motion to withdraw, yes.
And are you aware, let me back up. Have you seen that motion, sir, the written motion?
I have seen it.
Did they give you a copy, the paper copy?
I believe it was delivered to me in the jail.
Right, do you have that in front of you today?
He didn't read it though.
Madam Clerk, why don't you print off a copy and we'll give it to him. Just that. Well, it looks like Attorney Perry has put that in front of Mr. Brooks. The court is providing another copy. Mr. Brooks, can you acknowledge for me that you have a written copy of the motion to withdraw now in front of you?
Yeah, this is a motion to withdraw.
Are you able to read that on your own, sir?
Yes.
Have you read it?
He does have a punchable face. I want to break his face.
As of now, I have read it.
As of
Do you
now.
understand what's in that motion?
Yes, I'm aware of what's in the motion, yes.
So again, he doesn't
Anything about that
understand.
motion you do not understand?
I'm aware. I'm aware of it.
My question is, do you understand?
I'm aware.
Do you understand what it says, sir?
It's clear to me what it says.
All right. So let me start off
playing
again
semantics.
by asking you, do you wish to represent yourself in this case?
Yes, I do.
Before, I'm sorry, go ahead.
I would like to represent myself pro per.
Proper.
What does that mean to you, sir? Explain to me that
Again.
request.
Again, because I've already said it on record, to represent myself as a sovereign citizen.
So the reason why the judge is confused, right? No one really uses propria persona. Hey, Mega. They really don't use that term when you're representing yourself. It's always, pro se. And I think that the reason why he chose propria persona is that in Latin it means to represent your one self or your true self. So this falls into line with the sovereign citizen nonsense that they are a living human being and they're their true selves and their I don't know, representative self is a corporation and isn't real, blah 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 blah. And that's why I think that he chose this rationality from reading the Black's Law Dictionary. Doesn't make any sense, but that's what I think.
I'm not going to make a determination, sir, whether you're a sovereign citizen or not. It's not relevant to my determination how you characterize who you are, other than you are accused of 77 counts, which I will go through momentarily, and you have the right to have an attorney represent you. That's your
By the way, he was originally charged with 77 counts. One of the charges was dismissed. And do you know, he argued about why did the prosecution dismiss the 77th case, the 77th charge? Not that I was being done a solid. Yes, why they drop it? Dumb. He's smart enough. He has the raw material to be smart, but he knows just enough to be dangerous.
constitutional right. You have two very capable attorneys that have been with you from the beginning. You understand that, right?
No, I do not understand that.
What don't you understand about that, sir?
I don't understand why is a reference being made to the capableness of my attorneys. Now, I agree that they have worked tirelessly on a lot of the things in this case. And I credit them with that. I'm appreciative of that.
Lies.
But it also should be said that there's a lot of things that I did not understand about the proceedings in a lot of the court cases. There were things that I didn't understand why there wasn't certain motions filed. There were a lot of things that I did not understand the totality of the meaning behind. And that is what kind of led to a lot of issues, but these were issues that were being raised for a number of months. This was not just something that sprung up out of the blue.
So let me translate that for you. What that means is I want to participate in my case. And instead of you advising me, attorneys, instead of you advising me on what I should do to mitigate some of this responsibility or to explain in a legal, cogent way, I want you to present sovereign citizen BS because I feel that I know more than everybody here. And so, because you won't do what I want you to do, I'm going to fire you and I'm going to do it myself. And I'm going to show you that I'm smarter than everybody in the room because I know. I know. I know.
And I feel that as my attorneys, that it would be essentially their job to make me aware of things that I do not understand. So that's where questions come into question as you.
So you see the strangeness of this request. He wants to represent himself in a case where he has 77 charges and 6 people dead, right? He's facing about a millennium in jail, a whole millennium in prison if you add up all the charges. He doesn't understand. Yet he wants to represent himself because somehow he'll understand.
So let me follow that up, sir. If I allow them to withdraw, you lose their legal experience, their specialized training, right? Their education, their work as attorneys. Do you understand that?
No, I did not understand.
No, he doesn't
So
understand.
if you are allowed to represent yourself in this case, sir, you will have attorneys assisting you. If I let them withdraw, they're gone from this case. Do you understand that?
I think I will probably be better served myself.
I can go ahead and tell you, sir, that you were not better served at all. At all. You got a millennium, bruh. 6 consecutive bids.
So in order for me to evaluate whether that's appropriate in this case, there's certain things that I need to go through with you and on the record.
This is the
Okay, you
colloquy.
understand that?
Yes, Your Honor.
So let's start with the charges in this case. And I'm going to group them together. And if you have any questions, you need to ask me. Do you understand that?
Yes, ma'am.
So first of all, sir, you are charged 6 counts of first-degree intentional homicide, use of a dangerous weapon. Do you understand that?
No, I do not. And what I don't understand is the nature and cause of the charge.
Have you been provided with a copy of the second amended criminal complaint, sir?
I cannot say that I have.
I have a copy for you. It was filed on January 12 of 2022. I'll have my clerk hand it to the bailiff. You will be provided with it. While we're giving that to you, Attorney Perry, have you provided Mr. Brooks with a copy of that previously?
I believe so. I think he was also provided a copy of it in court.
I would like to say though, since you said January,
That was filed on January 12th, 2022.
part of the,
So, sir, let me focus you back. I'm interrupting here for a second because I want to focus on this document. So this particular document was filed on January 12th of 2022. Take a look at it. This document details the factual basis the state is relying upon to support each and every one of the charges. Do you generally understand what a criminal complaint is, sir?
no, I do not.
Well, it's in front of you. Are you able to read it?
Yeah,
I
can
don't
read it.
mean this moment, but do you read, write, and understand English?
Yes,
Right? Remind me again of the last grade you completed
I have HSED,
and how many years in school did you actually attend before obtaining your HSED?
11 years,
How long after you went to school through 11th grade did you obtain your HSED?
immediately.
While you were in school, did you have any special education classes?
Minimally,
Any of those deal with reading or reading comprehension?
no, ma'am.
Do you believe you have any issues with reading documents in this case from a comprehension standpoint?
Absolutely not.
Do you know at what grade level you read? Do you believe it's a high school educational level, a college level?
I don't know. I wouldn't be able to guess that off the top of my head, but I'm pretty sure that it's adequate.
Any physical or psychological disability that would affect your ability to understand the paperwork that's given to you in this case?
Not paperwork wise, no.
Any physical or psychological disability that you believe would affect your ability to communicate in the courtroom, whether to me or in front of a jury?
Absolutely not. I'm doing a good job now.
You are answering my questions.
So you hear, and look at the look on his face. I wish I could zoom it in. He's got this smug look on his face. I'm doing a good job now. I'm doing a good job now. Because his goal is to control the courtroom and control the scene. There is a sovereign citizen court survival guide that I found online, and it's very fascinating to watch. So they have all these different scenarios that they try to show people how to um, magically say the right words and do the right things in order to get the case dismissed, right? So we're in the stand on the Sixth Amendment and expose the truth phase. So in this manual, it says um, the setup. They have to ask if you understand the charges. There's no way around it. They cannot legally proceed against you until you acknowledge the charges explicitly and their jurisdiction implicitly. The Sixth Amendment says that you have a right to know and the authority to require the court to explain, and the court has the duty to explain. So, by you declaring that you do not understand the charges, you will steer the judge and the court into a legal position where she must answer all of your questions. Then you will hang the judge up on the questions using her own rules of procedure. This is where the sheep outsmart the wolves. I can go ahead and tell you that the shit didn't work, but this is what he's doing. Hey, Master Funding, it didn't work, but that's what we're watching.
And I appreciate that. So, do you understand, sir, that you are charged with 77 different counts as it relates to conduct of yours that is alleged to have occurred on November 21 of 2021 in the city of Waukesha?
No, I do not understand, and I say that because I'm still trying to. I would like to know the nature and cause of the charges.
Sir, listen to me and listen to what I'm asking you. Do you understand that you're facing 77 charges as it
No, I
relates?
do not
Hold
understand.
on, let me get my question out. Sir, and I will start a little bit more basically. Do you understand that you are charged with a variety of offenses due to conduct that you are alleged to have done stemming from an incident or a series of incidents from November 21 of 2021 in the city of Waukesha?
No, I do not understand.
Do you understand you're facing criminal charges, sir, in Waukesha County?
No, I do not.
So you have no idea that you are facing 77 different charges?
No, I do not. I would like that explained to me.
Okay, so what he's trying to do is he's trying to force the judge into answering questions. So in the book, it says when the judge asks if you understand the charges against you, you say no. The judge will then probably try to intimidate you by explaining them again in a condescending or stern voice, or by implying that you are lying. Here's what you must politely present your need to have answers so that the judge must decide to answer your questions. The judge will have to ask you exactly what it is that you do not understand. So they have a sample response, which is, Your Honor, the Sixth Amendment of the United States Constitution grants me the right to know the nature and cause of this action you're bringing against me, and it grants me and it grants you, the court, the duty to tell me I do not understand the nature and cause of this action. Remember, he just said that, which has been brought against me. The judge will have to allow you to ask her your questions, no exceptions. The judge will probably say, what is it that you would like to know? So they have these scenarios planned out, okay? And it's supposed to go just like what they think. And it doesn't work that way because there's a misstatement of the law. The judge does not have to explain to you what's going on. That's what you got these folks for. She just wants to make sure that you understand that you've been charged and the potential sentence of if you were convicted of each charge, not whether or not you understand the cause and nature of the crime. That's what them two for.
if possible.
Have you asked your attorneys to explain that to you?
There you go.
I believe I have a number of times.
Do this a little bit differently, sir. Okay, you are charged with 6 counts of first-degree intentional homicide with an enhancer for the use of a dangerous weapon.
Let me see.
The charges of first-degree intentional homicide, use of a dangerous weapon, carries a penalty of lifetime imprisonment. That means the information in this case alleges that you caused the death of another individual, in this case 6 other individuals, with intent to kill, contrary to section 940.01, sub 1 sub A of the Wisconsin statutes. That's a class A felony. Again, upon conviction, you shall be sentenced to life imprisonment. That's as it relates to the first 6 charges. Do you understand what I've told you, just what I've advised you thus far regarding the penalties for the intentional homicide charges?
No, I do not.
You don't understand that these are punishable by life imprisonment?
I would like to still know the nature and cause of the charges.
Sir, I'm focused on the penalties right now and the charges. Please answer my
I
question.
do not understand.
Did you hear what I just said right now?
Absolutely.
You are charged additionally with 61 counts of first-degree reckless endangering safety, use of a dangerous weapon. These charges are Class F felonies, and upon conviction, you may be fined not more than $25,000.
Thank you,
or
Mega.
Not more than 12 and a half years, or both. This too has an enhancer for use of a dangerous weapon, which means the maximum term of imprisonment may be increased by not more than 5 years. Did you hear me advise you of these penalties, sir?
Yes, I heard you, but I do not understand the nature of the cause of the charges.
There are also an additional 6 counts of what is referred to in the information as hit and run resulting in death. Each one of these 6 counts is a Class D felony. And upon conviction, you may be fined not more than $100,000 or imprisoned for not more than 25 years, or both. Sir, did you hear me tell you about the penalties for these offenses?
Yes, but I don't like the nature of the cause of the charges.
Sir, did you hear me tell you about the penalties for these offenses just now?
I don't understand the nature and cause of the charges.
I'm not asking you that, sir. Did you hear me advise you of the penalties for hit and run resulting in death?
I don't understand.
Did you hear me tell you about the penalties for hit and run resulting in death?
I don't understand the nature and the cause of the charges.
But that's not my question, sir. So stop playing games with me right now, okay? Did you hear me tell you the penalties for hit and run resulting in death?
Doesn't mean I understand.
I'm not asking you if you understand. I'm asking you, did you hear me advise you about the penalties? Are you able to hear me right now?
Yeah, I can hear.
Did you hear me advise you about the penalties for hit and run resulting in death?
I don't understand the nature and cause of the charges.
Again, sir, did you hear me right now?
I heard you right now. Yeah.
Did you hear me tell you the penalties? Yes or no?
Yeah, I heard. Understand.
I'm not asking if you understand. Sir, you're the one who wants to represent yourself in this case. So I need to go through all of the penalties with you. There are 2 counts of felony bail jumping. Each one of those counts is a Class H felony, and upon conviction, you may be fined not more than $10,000 or imprisoned not more than 6 years or both. Did you hear me tell you these penalties just now?
I don't understand them.
Did you hear me?
I heard you.
Okay.
There are also 2 counts of misdemeanor battery domestic abuse.
Oh, I wonder, was I muted this entire time? Oh, well, screw it. I'll read it over again later. Here.
Each one of these offenses is a Class A misdemeanor, and upon conviction, you may be fined not more than $10,000 or imprisoned not more than 9 months or both. Each of these charges is an act of domestic abuse. Costs upon conviction would include the domestic abuse assessment imposed under Wisconsin law. You understand, sir, what I have just told you about the penalties for misdemeanor battery?
No, I do not.
Did you hear me?
Yeah, I heard you.
Okay, sorry about that, guys. Okay, so what he's doing here is in the guidebook. It says use the semantics in your favor. Once you have done your research and homework, you will see that the entire legal system and statutes are rife with ambiguous, deceptive, and contradictory terms and definitions. You can use your knowledge of those terms which apply to your case in your maneuver and cornering techniques described above. All statements, rulings, and directives issued by the judge are subject to your careful scrutiny, interpretations, and legal implications. Don't budge away from it until it completely is resolved to your satisfaction with a judicial determination. Hang them with it. So, but the whole stream wasn't muted. It was just me that was muted, right? Y'all still heard her talking, right?
Sir, I calculated the exposure for all of these offenses in two ways. In Wisconsin, when a person is convicted of a felony, under truth in sentencing, there's a maximum term of initial confinement and a maximum term of supervision that a court can order. So for example, for a lifetime offense such as the Class A felony for intentional homicide, obviously the maximum is life. Do you understand that?
No.
Did you hear what I said?
Can you repeat it?
For a Class A felony for first degree intentional homicide, do you understand the maximum is life imprisonment?
No, I do not understand.
Did you hear me?
Yes, I heard you.
So this another part that I had read earlier that I was muted on. The strategy that he's employing now is called bait, steer, and corner. Hey, just looking. Bait, steer, and corner. So this is the main tactic to use for manipulating the judge into dismissing the case. This is all that he's been trying to do is get the case dismissed. The idea is to bait the court with questions concerning your confusion and then steer the judge into providing answers which force him to make a judicial determination or ruling, which exposes his or her mistake for fraud. It's like painting the judge into a corner from which there is no legal way out that allows them to continue the case against you. A classic cornering question to ask is, okay, now, just so I understand you precisely, has your honor made a judicial determination that, and then fill in the blank. And the answer should be something that would incriminate the judge. So that's what he continues to try to do this entire time. If you watch the trial, you know he always asks, is this a judicial determination? Is this a judicial determination? That's part of the strategy that he's trying to employ.
For the first degree recklessly endangering safety charges, if I were to calculate all of the imprisonment that you face from a maximum standpoint, it would be 762 and a half years plus an additional 305 years for the enhancers.
You heard that? 700 and something years plus 300 and something years. That's 1,000 years. That's over a millennium in prison. A millennium. Jesus will be back before he is able to get out. That's how crazy this is. And he wants to represent himself. He wants to represent himself. A millennium. What?
For use of a dangerous weapon. You understand that?
No.
Did you hear me just now recite that though?
Yeah, I heard you.
I heard you. A millennium.
For the 6 charges of hit and run, the maximum exposure that you face for just those 6 offenses alone is 150 years. Do you understand that?
That's another 100 years. That's another 100 years. And he's sitting there rocking his chair back and forth like nothing's happening.
No.
Did
No.
you hear me say that though?
Yes.
For the 2 counts of felony bail jumping, the maximum for both offenses is 12 years imprisonment. Do you understand that?
No.
No.
Did you hear me say that though?
Yes.
For the 2 Class A misdemeanors, the maximum is 18 months, meaning 9 months plus 9 months. Do you understand that?
No.
But did you hear me say that?
Yeah, I heard you.
You heard me advise you of all of these penalties. Is that right, sir?
Yes, I heard you. Do not understand, but I heard you.
Can you continuing with that? I don't understand.
Sir, do you want to be represented by a lawyer in this case?
No, I do not.
Do you understand that you have a constitutional right to be represented by a lawyer in this case?
I'm aware that that is one of my rights under the Constitution, yes.
You understand that if you do not have enough money to hire your own lawyer, you may be entitled to have a lawyer appointed to represent you. Do you understand that?
I'm aware, yes.
I've already gone through the charges and the maximum penalties of imprisonment for all of these offenses. If you are represented by a lawyer, he or she may discover information or facts which would be helpful in your defense. A lawyer may find that you have a defense to the charge or that there are facts which may result in a lighter penalty. I want you to take this into consideration in deciding whether or not you want a lawyer to represent you. I also need you to understand that the trial will continue under the same legal rules that would apply if you had a lawyer. If you represent yourself, you will have to follow these rules. Because you are not trained in the law, this will make it hard for you to challenge the evidence presented by the state and hard for you to present any evidence that you want to present. If you decide to testify, you will be sworn as a witness and can give testimony while you are acting as a witness. You will be asked questions by the other side at that time. However, you cannot try to testify while acting as your own lawyer. Do you understand these things, sir?
No, I don't, because it sounds like pro se to me.
Okay.
Because it sounds like what?
Sounds like pro se to me.
Well, there are 2 options here. Pro se means you act as your own attorney. You're self-represented.
Listen to this.
So when I talk about not having a lawyer, representing yourself, acting pro se, those are all the same. They all have the same meaning. Do you understand that?
No, I do not.
No, I do not.
My understanding that it's not the same meaning as representing yourself as pro per. And if that could be clarified for me, then it would greatly help.
Okay, so according to the Sovereign Citizen Survival book, not pro Satan, pro per. So in the survival guide, under the section representing yourself as a sovereign citizen, it says you should represent yourself always in propria persona, in your own person or pro per. This alone qualifies you as an attorney in fact, according to Black's Law Dictionary. By asserting your sovereign right to represent yourself in legal matters, you are establishing your status as your own attorney without being misled, trapped, and overcharged by a licensed defense attorney who would only bind you into the very system which is dedicated to making you pay. Do not hire a licensed attorney if you intend to keep your rights and your money. There is no law which requires anyone to hire an attorney. If anyone tries to intimidate you or deny your rights by asking if you are an attorney, you can always reply, "In fact, I am." Bring your flag. Listen to this shit. Bring your flag with you wherever you appear in court to show your sovereignty. By representing yourself, you are free to expose any of the many fraudulent deceptions and procedures being used against you. The court can assign a public defender to you if you want to just pay some money and get out. But remember, the public defender is just an officer of the court, trained to only reduce the fines in exchange for pleading guilty. If you do this, you will not be allowed to expose the corruption, you will lose your case and your money, and you will have a conviction record. Bruh, you already got one. You have a long list of convictions and you pled guilty. He ran over another girlfriend. He got convictions for strangulation, he's a sex offender because he impregnated his baby mama when she was 14. Or sorry, dated her when she was 14 and impregnated her when she was 15 and he was 23. What are we talking about here? So in order to effectively represent yourself and your interests, your mission, should you choose to accept it, is to proceed in propria persona or proper. This is what you must sign on every court document next to your name. This means that you are not only the legal counsel representing the defense, but you're also the accused whom you are representing in person. Do not represent yourself any other way. This also means that the judge cannot lawfully hold you responsible for conducting yourself or your case as a licensed attorney, nor can she force you to hire one. You are free to proceed as you see fit as a sovereign citizen. Your legal counselors are just that, counselors, and there's no law preventing your friends from consulting with you during any court proceedings. Do you hear this nonsense? So basically, long story short, in his mind, that going pro per means that he can defend himself, but he is not held to criminal procedure, to legal protocol. He can just do whatever the hell he want to do, and it should fly because he's not a licensed attorney. That's what he's trying to say. And because he can do whatever he wants to do, he does not have to abide by the rules of evidence, the procedure, filing the correct motions, making objections in the correct time. None of that. You don't have to bother with none of that. That's what he means by that. Dumb.
Sir, under the Constitution, you have a right to have a lawyer and you have a right to self-representation. Those are the only two rights that I am talking about today.
I'm aware of that.
He's aware.
So whatever your understanding about some other hybrid fashion is not what I would be proceeding under. Do you understand that?
No, I do not.
What is your expectation, sir, about proceeding on your own in this case, in this have said?
I simply seek to represent myself pro per so that I can establish my sovereign citizenship.
According to the guide, some judges and prosecutors will expect you to proceed pro se, another method of representing yourself. Do not let this happen because pro se means that you are legally representing yourself as your own attorney, which the court can then pervert to mean that you can be told by the court how to proceed with your case, and the judge may try to impose the same standards upon you as are imposed on a licensed attorney. The court would be allowed to treat you as your own attorney, differently than it would treat you as the accused. So don't let this happen. You will know when to declare your pro per status. Baby, that is not, yes, it was going to be a series. It's going to be a series. It's too much to do one thing. It's a must. And we're going to hit the highlights and the lowlights.
But what does that mean as to whether you have an attorney or not to you?
Clarify what you're saying, what you're asking.
You keep repeating this phrase, is it perf? Spell it for me.
Yes,
I want to
pro-per,
make sure
yes.
that I have the right words that you're using.
You want me to spell prior persona or pro per? Which one?
Tell me what you think you want to do in
Look at this asshole's face. I can't stand him. He's sitting here like Dr. Evil, like he is the smartest thing ever. And gonna get smart with the judge and say, what do you want me to spell, pro per or propria persona? Like she doesn't know what it says. And she went to school, which you didn't go to, obviously.
this case and what phrase or term that you're using and what it means to you.
Your Honor, I just stated on the record what I would like to do. I don't think
Spell it for me.
PROPRIAPERSONA.
And what does that mean to you, sir?
It means that I am representing myself as a sovereign citizen of the United States.
That doesn't mean that.
Does that mean you have an attorney or not have an attorney representing you, to you?
It means that I am representing myself in all legal matters. So that would say that I am my own attorney.
Do you understand, in order for me to honor that request of yours means you must waive your right to an attorney in this case?
Can you clarify that for me?
Asking questions.
You need to honor this request of you to appear pro persona as a sovereign citizen. Let me back up. What you're telling me is that you want to represent yourself and you're describing it as pro persona. Fair enough? Do I have that right?
Yes, ma'am.
All right. What I hear when you say that is you want to represent yourself and exercise your right under the Constitution to be your own attorney. That's what I understand your request to be. Am I wrong in my assessment of that?
No, you are not.
In order for me to recognize your request and grant your request, you must waive your right to counsel in this case. Do you understand that?
Is it case law on that would give me clarification?
I can't give you advice, sir. I'm just asking you questions. All right?
Okay, so according to the book, the survival guide, this is also part of the steering with questions, and they actually have a scenario where it's so crazy, but they have diagrams on what the proposed response should be and then what the outcome should be. So part of it literally is question 3. Do you have a copy of the rules of criminal procedure under statutory jurisdiction in your office that I could borrow? Where does this nature, cause, and jurisdiction information exist? Do you know of a law library anywhere that has a copy of these rules? Since I'm defending myself pro per, isn't it your duty to specify which rules of criminal procedure will be used? Jesus Christ. So that I may conduct a fair defense and a fair trial, you must tell me where I can access a copy of the rules. So you just heard him ask, where is there any case law or something he can look it up? This is part of the scenario. And then, according to the scenario, he says, It says, this is where you will win. The judge must either lie or dismiss. I don't think that happened, did it? The truth is that they have just committed to a statutory jurisdiction, and there is no such thing, not to mention no official published rules to use. In some cases, the judge will make faces at the prosecutor, and the prosecutor will motion to dismiss for some other phony reason. Either way, you win. This is literally in here. I'm going to have to post a link to this thing. This is great reading.
Understanding is, I don't see how that comes into play. I don't. That's why I'm asking, is it a way that can be, that part of what you're saying, just that part can be clarified to me, because that was not my understanding, that there had to be some waiver of rights and things
Sir,
of that
in
nature.
order for you to represent yourself, you need to waive your right to counsel in this case. Do you understand that?
No, I do not. It's not clear
It's
to
not
me.
clear.
Is that a
You can't
way?
have it both ways, sir. You
I'm
either
not trying to have it
have,
both ways.
listen to
I'm
me,
just asking.
you either have an attorney and you're exercising your right to have an attorney, or you waive your right to an attorney and you act as your own attorney, what I refer to as self-representation. Doesn't matter to me what phrase you put on it. The Constitution guarantees you the right to have counsel, and it guarantees you the right to represent yourself. In order for me to honor your request to represent yourself and allow that in this case, means you must exercise, you must waive your right to an attorney.
Now, since you just broke it down that way, it's a little bit more clear.
It's more
That's
clear.
all I was asking.
Mm-hmm.
I don't necessarily know, right, what's going on in your mind. That's why I ask a lot of questions. So do you now understand that, sir?
Yeah, I would like to weigh that right to counsel. I would like to represent myself from her as
Okay, so he's waived his right to counsel and he wants to represent himself to pro per. You heard the judge explain very patiently to him that in order to have self-representation, to represent himself, he has to waive his right to counsel. And he said, okay, this is important to remember because he's going to bitch and complain later on about the fact that he does not understand and he doesn't have an attorney. Might I add, this came out, this was on September 27th when this occurred. Trial started on October 3rd. So he had 3 days in order to represent himself with over a millennium on the line. 3 days.
I stated this.
Part of the decision I need to make, sir, is to evaluate certain criteria. It's why I asked the questions earlier in part about your level of education, your level of literacy, your ability to communicate in the courtroom, etc. Do you remember me asking you those questions?
Yeah, I remember you asking me that.
So another thing that I have to evaluate those, sir, because ultimately I have to make a determination that you are knowingly, intelligently, voluntarily, and deliberately making a choice to waive your right to counsel and represent yourself. And in order for me to do that, I must establish certain things, including that you understand the charges and the penalties you face. Does that all make sense so far?
Yes.
You may have a lack of understanding about the nature of the charges and may have questions regarding that. But my role here today is not so much to explain all of those nuances and explain the basis for the charges, but to make sure you understand what charges you face and the penalties for them. Do you understand the distinction?
Yeah, it makes sense to me.
It doesn't. Doesn't make sense.
So I'm going to go back to these charges again, sir. Do you understand you're charged with 6 counts of intentional homicide? I'm not, and let me preface, I'm not asking you if you understand why. I'm asking you if you understand that these particular 6 charges have been filed against you.
I'm aware.
I'm aware.
And are you aware of the penalties if convicted, for each count of first-degree intentional homicide?
You said a lot of numbers, so.
Well, and I can go back to them, and I'm okay. This
No, we
is
don't need to-
important.
we don't-
So
we don't need to do all that.
first-degree intentional homicide is a Class A felony, and upon conviction, you shall be sentenced to imprisonment in life. Do you understand that?
I'm aware.
All right. And are you aware that there's also an enhancer for use of a dangerous weapon?
I don't understand that, but I'm
Are you
aware.
aware?
I'm aware.
All right. Are you aware that if a jury finds that you committed the offense of first-degree intentional homicide by using a dangerous weapon, that maximum term of imprisonment for this felony may be increased by not more than 5 years? Essentially, it adds 5 years for each offense convicted, with that question being answered by the jury, yes. Do you understand? Are you aware of that?
I'm aware.
You see, he's kind of getting flirtatious.
And are you aware, sir, that you face 61 counts of first-degree reckless endangering safety use of a dangerous weapon? Are you aware that each one of those 61 felonies, upon conviction, you may be fined not more than $25,000 in prison, not more than 12 and a half years or both? And are you aware that if convicted and the jury answers the question yes about using a dangerous weapon, each of those terms of imprisonment may be increased by not more than 5 years? Are you aware, sir, that you are also charged with 6 counts of hit and run resulting in death?
Now
Are
he's
you
he's
aware
low.
that each one of those Class D felonies is punishable by imprisonment up to 25 years?
Did you say 25?
I hope I did. If I didn't, it's 25 years. I'm reading it right from the,
I probably missed it.
Uh-huh.
there's a lot of charges, and I understand that there's a lot of numbers.
Yeah.
Yeah.
But are you aware that a Class D felony for hit and run resulting in death is punishable by a fine of up to $100,000 and imprisonment of up to 25 years?
I'm aware.
Are you aware that you're charged with 2 counts of felony bail jumping? Are you aware that each one of those counts carries a maximum term of imprisonment of not more than 6 years and a $10,000 fine?
I'm aware.
Are you aware that you're charged with 2 counts of misdemeanor battery domestic abuse? Are you aware that each one, as a Class A misdemeanor, the maximum term of imprisonment is 9 months and a $10,000 fine?
I'm aware.
Are you aware that they're each charged as acts of domestic abuse, so that upon conviction, there would be a domestic abuse assessment imposed?
That last part I don't understand. What exactly does that mean? The very last sentence.
Sure, it states as follows in the charging documents, that invoking the provisions of 968.075 sub 1 sub A, because this charge is an act of domestic abuse, costs upon conviction would include the domestic abuse assessment imposed under Wisconsin law. It's an additional $100.
Also, it's a fine.
It's a cost.
That's the least of your worries about a $100 fine for punching your girlfriend in the face. That's the least of your worries. The least. I don't think that he can count. He can't be able to count.
It's a surcharge.
Bail jumping. Yes, he
Technically, it's a
did.
Domestic abuse assessment.
Yes, he did.
The financial obligation, but when the court imposes it, it has some other collateral consequences that follow with it. I can't give you advice on what that is, but typically it involves prohibition of firearms. Are you aware of that?
Yes.
You know, because you are not a stranger to domestic violence charges. I know you do know.
Do you understand? Let me rephrase that. Are you aware, sir, that the state of Wisconsin is represented by District Attorney Sue Offer, Deputy District Attorney Leslie Basie, and Assistant District Attorney Zach Wichow? The three individuals seated to your left, my right.
Say the first part again.
Are you aware that the state of Wisconsin is represented by 3 attorneys here in court?
No, I do not understand.
Ah, yes.
Are you aware?
I'm not even aware.
So are you aware, sir, that the state of Wisconsin is the plaintiff in this case?
I'm not aware. This is where the confusion of that comes in.
Here it comes.
I have confusion to how the state can be the plaintiff.
Okay. So it's time to get to the handy dandy survival guide. This is strategy number 5. Refuse to recognize the plaintiff. This is perhaps a fallback strategy if strategy number 1, above, is not working. Here, you simply stand on your Sixth Amendment right to know the nature and cause of the accusation against you. So when they ask if you understand the charges, you say, no. In fact, I'm not even sure that the plaintiff is present. Or if the judge asks you if you are ready to proceed at any court appearance, repeat those words again. The point is, these cash register courts and DAs are all fraudulently impose their laws and accusations upon us under the color of law. They presume to represent the people of your state. They hide behind that title and then expect you to feel intimidated and guilty for offending the people. In reality, they represent the corporate state, in parentheses, banks, under the false extension of the corporate United States, parentheses, foreign banks. If you, who really represent the people, because the charges arise from laws which require the people's compliance without their consent. After all, weren't you simply minding your own business to begin with without injuring any party? The system is deliberately dysfunctional and the people are paying for it. So, this is one of the arguments that he makes all the time, is that there's no plaintiff because you cannot hurt the plaintiff. There's no state. I mean, the state is a legal entity and cannot be injured. This was one of his major things he said. I don't know who the plaintiff is. He asked those idiotic questions. Do you know who the plaintiff is in this case? Have you ever spoken to the plaintiff in this case? Have you ever had a conversation with the plaintiff? That's where this shit's coming from. Uh-oh. And there we go.
I am not going to give you legal advice regarding that answer, sir, but you have the second amended criminal complaint. And if you don't, we'll give you the information as well. These are called charging documents.
Oh, one more thing. It says here, in this strategy, you must also stand on your 11th Amendment right to protect from their foreign jurisdiction, because they are certainly not representing we the people. God, I hate when people say we the people. That means that I know that you're stupid when you say we the people. And it is you that is a member of the sovereign body of the state. As a de jure member of we the people, study the Constitution and Black's Law Dictionary definition of plaintiff, which is a injured party, foreign state, foreign interest, nature and cause, etc. Then you will really understand how their whole illusion and ballgame rests on giving your consent to their fraudulent representation of the case against you. So that's why they don't consent. And they always scream, I do not give consent. I do not give consent. This is freaking fascinating.
Documents, sir. And on the top of each one of those, on page 1, there's a caption. It says State of Wisconsin Circuit Court, Waukesha County. Do you see that?
I see that.
Do you see where it says State of Wisconsin plaintiff versus Darrell Brooks defendant?
Okay. This is why I'm confused. You have a lot of every document I ever got up until this point was like this with my name in all caps.
So what are you holding up? Is that the motion to withdraw?
Well, yeah, because it's the newest.
Right, so every legal document that is filed that's considered a pleading would have a caption. The caption is the information that says what court we're in, so it's circuit court, the county, Waukesha County, and tells the court who the parties are. The parties in this case are the state of Wisconsin as the plaintiff and Darrell Brooks as the defendant. Are you aware of that, sir?
No, I'm not. I need clarification on how the state of Wisconsin can be a plaintiff, because that would essentially mean that the state of Wisconsin is the injured party. How could the state be an injured party?
Y'all hear
Sir,
this?
I am not going to go down this path of giving you legal advice. Are you?
I'm not asking for legal advice.
Right, and I don't
I'm
need to
saying I'm
provide.
confused on how that can be. That's what I'm saying.
Well, the bottom line, sir, is the state of Wisconsin is the legal entity represented by the Waukesha County District Attorney's Office that brings charges against a defendant.
Alleged defendant.
Well, no,
Alleged.
you're a defendant accused of committing offenses. You're not an alleged defendant. You are a defendant, but the allegations are accusations.
Bruh, you are in an orange jumpsuit and you're shackled. You're not alleged. They've charged you. You've gone before a grand jury. You've been charged. You're not an alleged defendant. You're a defendant. Like, it's official. You're a defendant. Like, no questions. Now, the charges might be allegations because they have not been proven because you haven't been convicted yet. That's the alleged part. But you're a defendant, sir.
Are you aware of that?
No,
Are you now aware of it because I just told you that?
no.
No.
Well, we're going to start with this premise, sir, that the state of Wisconsin is the plaintiff. They are represented in this case by the Waukesha County District Attorney's Office. There's many attorneys in that office, but the three attorneys who are prosecuting this case are the district attorney, Sue Opper, one of her deputy district attorneys, Leslie Basie, and an assistant district attorney, Zach Witchow. They have been seated at the other table, whatever courtroom we are in, throughout all of the proceedings, or the vast majority of the proceedings in this case. You're aware of that, right?
No.
You're not aware that these attorneys, these people seated to your right, have been in court virtually every time that you've appeared in court?
The guy just came like the last few court days. I mean,
So you are aware because you made some observations.
well, the confusion with the question that you're asking is still, how can the state of Wisconsin be the plaintiff?
I'm not
How
going to
could
answer
it be
that
the
question,
injured
sir.
party?
I have a different reason for advising you. And what you need to know, what's important for my conversation with you today, is that the state of Wisconsin is represented by three attorneys.
Is that a judicial determination?
See?
That's their prosecutorial discretion, sir. So,
So they're the
but what,
injured
hold
party?
on, nope. Let me ask you the questions and
So as you see, he's going and doing his strategy of asking questions to try to confuse and to try and force the judge into explaining things to him to make a quote unquote judicial determination, because he thinks that that way he can have a mistrial and win. That's their logic. I don't get it, but okay.
tell you certain things. What I want you to know is that the three attorneys appearing on this case have a collective, if I did my math right, 66 years of experience as attorneys. Did you hear what I said? Yes or no?
Okay, 66 years of experience as attorneys. Okay.
Okay.
So I'm gonna ask them a couple questions and I want you to listen carefully. Attorney Opper. Yes, ma'am. Has your entire career been as a prosecutor?
Yes, ma'am, since 1991.
How many intentional homicide cases can you estimate for this court that you've been involved in?
And
That's just before me. Is that how you took that question or is that total?
oh, I'm sorry, total in the course of my career.
All right, so 10 intentional homicide cases that actually went to trial or just prosecuted in general? I wasn't very clear on my question, so.
Okay. I would say probably 8 of those would have gone to trial. This is a ballpark, Judge.
Right. Suffice it to say, you are experienced in litigating intentional homicide cases.
Yes, ma'am.
You're also experienced in litigating reckless endangering safety charges.
Yes, ma'am, I've had many cases like that over my career.
How many trials do you think you've participated in over your 31 years?
I would estimate 200.
Attorney Basie, similar questions. You have, I believe, 27 years of experience.
I do.
All of that as a prosecutor?
Yes.
Can you estimate for the court how many trials you have been involved in?
125.
Very precise. Any of those intentional homicides?
Yes.
Any of those involve recklessly endangering safety charges?
Yes.
Now, Attorney Witchow, you're what we call the baby of the bunch. My understanding is 8 years of experience.
Yes,
All of that as a prosecutor.
yes.
So the judge is in a roundabout way trying to warn him. These people who are prosecuting you have a collective experience of 66 years, give or take. You're coming in here after 3 days of no preparation. You will not have the knowledge and the expertise of them three over there. And it's going to be a David and Goliath type thing. And like they said, a man that represents himself has a fool for a client. That's what she was trying to say in a polite, roundabout way.
Have you been involved in an intentional homicide trial before?
No,
In addition, Mr. Brooks, first of all, did you hear the answers to the questions I just asked these attorneys?
Yeah, I heard.
I mean, you understand, sir, they have a lot of experience sitting at that table. Would that be fair to say?
Roughly.
You also understand, though, that they have at their disposal an investigator with the Waukesha County Sheriff's Department. I mean, they're assigned, that person's assigned to the district attorney's office to help them, even during a trial.
I don't understand where we're going with this.
Just want you to understand the resources that you're up against when you represent yourself.
Doesn't make me flinch one bit.
And I'm not asking you whether you're flinch, I'm asking you if you understand it.
I still go back to the question I asked. I don't understand how they can represent an injured party. How can the state of Wisconsin, the corporate state of Wisconsin, be an injured party?
God in heaven. Again, I try to point out this punchable face. I point out this punchable face and the look of arrogance. And look at his attorneys. They look so tired. They look so beat down. They're ready to go. Like now. They're tired.
I'm not answering that question. Okay, this is
So
a
is that a
legit,
judicial determination that you're not answering that question?
no, sir. This is a legitimate case. And I'm not going to make a mockery by you asking that question. Because this case has been proceeding since November 23 of last year, and it's going to keep going on, whether you understand how the state can be a party or not. Do I make myself clear?
No, because the question is still there. It's still a relevant question.
I'm telling you, I'm not answering the question, and whether you understand the issue or not is not going to stop this case from going forward.
So is that arrested judgment?
So I also want you to be aware that the district attorney's office has available, because the case involves witnesses from the city of Waukesha Police Department, that they will have seated at the table behind them, currently seated now, Detective Tom Casey. Are you aware of that?
I'm still going to refer back to the question.
Sir, answer my question. First of all, did you hear me ask the question? Did you hear me? Yes or no?
No.
So I'm telling you, Detective Casey is going to be their court officer throughout this case. Did you hear me say that?
How?
In addition to Detective Casey being here, the district attorney's office also has
Hello.
support staff that
How? Ooh, y'all, I wouldn't be able to sit with a straight face with this dude at all. At all. You see that the attorney, the guy over here, you see he's laughing. He got his head turning. He's laughing at this foolishness because he know it's stupid. It's a game. He is stupid as hell.
will be available for their use during this trial. Did you hear me say that?
I'm still not understanding how there are questions not being answered.
Sir, did you hear me tell you that right now?
Did the court hear me ask the question of
Mr.
how can the
Brooks.
state be a plaintiff?
Mr. Brooks,
Is
gotta
there
answer.
some type
I'm
of
not-
case law you can point me
I'm
to?
not allowed to give you legal advice, nor will I.
I'm not asking for legal advice.
The whole point of this, sir, is that I need you to be aware that many people are going to sit on the other side of the courtroom working towards presenting this case and seeking convictions on all charges. Now, seated next to you are attorneys Perry and attorney Keys. My understanding of their experience, sir, is that Attorney Perry has been practicing for 20 years. Attorney Perry, is that true?
Yes,
All of that with the Public Defender's Office.
that's right.
You have experience both now in the trial courts and appellate courts, is that true?
Yes,
And throughout that experience, you have litigated intentional homicide cases.
I have.
Also been involved in, I would imagine, cases where the charges involve recklessly endangering safety,
Yes,
hit and run, resulting in death.
it's possible. I don't know.
So again, she's saying that these attorneys, your attorneys that you have not discharged yet, have the experience needed because they have tried cases like this or defended cases like this before to help you. Know what I mean?
Attorney Keys, my understanding is you have 12 years of experience.
Yes,
All with the Public Defender's Office?
in criminal defense.
All in criminal defense. And you've been involved in intentional homicide cases as well.
Yeah,
Suffice it to say, you and Attorney Perry have dedicated your careers to representing the rights of people accused of crimes.
Yes,
Take that job very seriously.
I do.
Attorney Perry, same thing, right?
Yes.
Mr. Brooks, did you hear me ask your attorneys about their experience as attorneys?
Trying to understand what is the relevance.
Sir, did you hear me ask them about their experience?
The relevance.
Sir, did you hear me ask them questions about their experience as attorneys? Yes or no?
What is the relevance, Your Honor?
Since you're questioning the relevance, I will presume that you heard me and understand that you are seated next to attorneys who have dedicated their careers to the representation of individuals accused of crimes, and that they're very experienced at that.
So you're assuming something that I did not say.
The other thing that I need to make sure you are aware of, sir, is what the state would have to prove in this case in terms of the elements of the offenses.
Now, really quickly, this is part of their strategy. I don't know if I read this. This could have been when I was muted, but it's admit nothing, ask questions. Every question you answer in court digs you deeper and deeper into the jurisdiction hole. Your answers automatically give you implied consent to the court's jurisdiction and authority over you. And everything you say is already being used against you. They are trained, just like the officer, to get you to admit things to incriminate you. So it is in your favor to admit nothing and keep asking questions. This way you will control where this discussion and evidence is going. Okay? And another one is act dumb, play smart. From the above game rules, you can easily see that it is to your advantage to lull the judge into a comfortable position so that he or she will more likely expose or admit some mistake on the record. So, one of the most powerful ways for you to play is to act dumb at first and then quietly go for the throat when they slip up, expose themselves, or find themselves stuck in a lie. Most of the examples in the details below are of this strategy. And lastly, smile, give thanks, apologize, and ask. This is one of the most successful strategies in the initial appearances, consistent with number 4 above, which is the act smart, play dumb. It works because the judge will form a favorable opinion about your honesty, innocence, and sincerity, and then grant your request without suspecting anything. I don't think that worked either.
I presume, but I want you to confirm that you understand the state of Wisconsin bears the burden of proof in a criminal case.
I'm not going to confirm anything until the question is answered how the state can be a plaintiff.
I'm not going to answer that question, sir.
Can it be
Shown to me?
shown to me by some type of case law?
You currently have attorneys representing you. I have not discharged them. If you have questions about legal topics, you can ask them. I'll even give you a moment. I'll step off, give you a couple minutes, 5, whatever, if you need to ask them those questions. Do you want that opportunity?
We're on the record.
I can pause.
No need to pause. Can the prosecution?
Sir, I'm not going, we're moving on. I understand you're not happy with the court not answering this question that you have, but I'm not going to answer it.
Well, that's essentially a rush to judgment.
I'm not rushing to any judgment, sir. My concern here is to make sure that you understand the charges you face, the penalties that are associated with them, that you're aware of all of these things, that you are aware that you as a defendant do not have to prove anything at a trial. Are you aware of that?
I can't move past the rest of the judgment.
There's no rest of judgment. And
Just
did you
assume-
hear me, sir?
You just assumed that I said something I didn't say.
We're gonna move on.
Look at her face.
We're moving on, sir.
How
Mr. Brooks,
can we do that though?
we are here at your request to represent yourself. We're going to move on because your question is not relevant to that inquiry. So I'm moving on.
But it's relevant.
And you don't
for
have
me
to like it.
No, it's not. It's not that I don't. It's
We're moving
I'm
on.
fine. It's just I find it hard for me to ask a question that's not relevant, but then it's relevant for me to know the
Mr. Brooks, we're
experience
moving
of
on.
everybody
And if
here.
you have the inability to move on, then this hearing is done.
It still has to be a determination made.
Sir? I would like to
Ma'am?
continue. So we need to move past this. And if you can't move past this, then I'm done.
Then I can still make the record.
Sir, do you understand that the state of Wisconsin must prove each and every offense beyond a reasonable doubt?
No, I do not understand until my question is answered.
Sir, are you aware that
No, I am
the
not aware.
state, I didn't even ask the question. How can
I'm
you
not
answer?
aware.
Mr. Brooks, are you aware that the state must prove every element of each offense charge beyond a reasonable doubt in order for you to be convicted?
No, I'm not aware. The state still has, I'm still confused. How are
Right,
they?
Attorney Perry, please, we're gonna go off the record. I'm gonna take a break. I'll mute the live stream. I'll even stop it for now. I'm gonna clear the courtroom. I'm gonna give you some time to talk with Mr. Brooks. I'm not answering his question, nor am I required to answer his question. But I can't move past this if he is going
Still
to
running his
keep
mouth.
interrupting. He's not demonstrated thus far that he understands enough for me to even get past that to make a determination that he can waive his right to counsel. So I trust.
Okay, so the live stream pauses here. So it's paused for a long period of time. Paused. They're off the record. I think that might be it on this one. Yep. 'Cause I think they paused for the rest of the day because of this. Yeah. So yeah, it was paused for the rest of the day. So I'm trying to see. I don't know if we want to get into the hearing the next day. I can play a little bit of it so I can try and get to the 2-hour mark and then let that be it for today. Let me pull up that. So that was, say, Wednesday hearing. So they had to get off of the record because Brooks was being a douche nozzle. Okay. So we come back the next day. Yes, it's definitely the sovereign book of horrible advice. This should be the sovereign book of getting 1,000 years. So this is the next day. We're back.
I did have an opportunity to review the exhibit that was
Hold on, I don't care about none of this.
hospital, and it was
Yeah.
argue at this time. It's your motion, Attorney Perry and Attorney Keys. So whoever would like to argue that, I'll certainly give you an opportunity at this point.
Thank you, Judge. Are you?
Yeah. I don't care. This is the part where the attorneys are saying that they have a difficult relationship with Mr. Brooks because of his sovereign citizen ideology, and they had to look at his mental stability. He's been evaluated by 4 clinicians because he had put in that plea of insanity, temporary insanity by mental defect or disorder. So, hey, Sister Mary. So, so they're going over his mental health status here, and the attorneys, like I said, they're tired. They're all tired, and that's what they're discussing. I'm just trying to get to the part where he's talking
Simple, but
because I don't really care about none of this.
especially in light of the phone call that was placed by Mr. Brooks and some of the other information.
Hold on.
They
I may have to come back to this one.
The defense is claiming a violation of Mr. Brooks's Sixth Amendment right to counsel and requesting dismissal of the entire action, or in the alternative, removal of those involved in that search from participation in the case. As this court held yesterday, there's no right to privacy in the jail cell. I'm not going to go through all of those findings here today, but they are important.
Hold on.
I don't know if the originals were on his own. No.
Okay, this is the wrong one. So yeah, what I'm gonna do is I'm gonna go ahead and just let it ride for the night. I had to find the correct video. I thought I had it, and this wasn't it. Or let me see. Hold on. I know I have it. Oh no, I found it. I found it. Hold on. Okay, I found it. Let's see. Is this it? That might be it. The 135. Okay, this is it.
Versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Your Honor. Sue Apper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
Darrell Brooks appears in person with his attorneys, Anna Keys and Jeremy Perry. Good afternoon.
Great. Good afternoon, everyone.
Yeah.
Hey,
today.
Kitty.
I'm sorry.
I'm here representing myself pro per.
All right, thank you, sir. Then we are here so that I can once again address the motion to withdraw that
He don't even have sense enough to let his attorneys talk for him.
was filed by the defense attorneys in this case late last week. I did receive this morning a filing from the defense. It includes the waiver of right to attorney form that appears to have been signed by Mr. Brooks. I want to start with the defense team, because it's still a team right now, Attorney Perry, and I want to get some information from you for the record. So if you could please tell me
They tired.
how many times that you have met with Mr. Brooks since you've been appointed. I'm looking for you to quantify that for me if you can.
I need a moment.
Sure.
They tired. Move. Stop. Stop, Paisley. Little troublemaker. Lord. Let me speed this on. This is boring.
To him or him to you. I'm not looking for you to divulge any, privileged information, just generally, how have you communicated with him?
There have been some times in writing.
Has he written to you at all?
Yes.
Have you had any concerns with his ability to communicate with you either orally or in writing at any point in time during your representation?
I want to answer the court directly, but I'd like to answer this way, is that, and maybe this is not what you're asking, but we are very aware of our obligations in terms of raising any concerns, if there were, about competency or the ability to communicate. And
I'm not looking
You're
for
not-
that.
you're not
No, I'm
inquiring.
looking more for your assessment of his literacy and his ability just generally to communicate with you in the English language.
we've not had any problem communicating with Mr. Brooks.
Thank you. It's my understanding that he provided to you or to Attorney Keys the waiver of right to attorney form that was he filed with the court this morning. Is that true?
That was delivered to us via a by jail staff this morning.
Thank you.
So he signed the form to waive his right to counsel.
I know that you also filed a case and really a summary of that case with the court. Is there anything you want to put on the record at this hearing regarding that filing?
Only that I think from some of the comments of Mr. Brooks, and I say this with the understanding that, you know, we view him, of course, our motion to withdraw has not been granted. We're still representing him. And it is our clear understanding that it is Mr. Brooks's desire and objective to represent himself in this matter. There were some things at yesterday's hearing that I think maybe seemed inconsistent with that in terms of colloquy with him, and some things that perhaps appeared inconsistent on his written waiver of attorney form. We provided that case law in that context of United States v. Banks with the exchange that has some real similarities to the exchange that happened in court yesterday, where, and this is, you know, if there's a distinction being made in the sense of what part of the Sixth Amendment does Mr. Brooks wish to waive in terms of how he sees himself as appearing in this case as a special appearance, pro per, as he has said, that the context of that with his really quite clear statements throughout yesterday's hearing of where I think he said multiple times that his wish is to represent himself in this matter. We provided that to try and place some of the sovereign citizen language in context where it is maybe not as inconsistent as it may first seem, to support what Mr. Brooks is saying he wants, and that is to represent himself in this matter.
What I hear you saying is that certainly prior to yesterday's hearing, Mr. Brooks made it very clear to you he wants to represent himself.
That's right. That's why we filed the motion to withdraw.
Okay, so I'm going to go ahead and end that there, and then I will do another part, go and give my commentary over the rest of this video, and then I will start with some of the trial. But to answer your question, Cold Brew, the judge he doesn't allow this "I don't understand" nonsense to go through. What she does is she just changes the wording. She plays a semantics game with him. With, you know, are you aware or are you informed of? Because he continues to repeat that. but it doesn't negate the fact that the form says it's a form that comes from the court. I understand. And she went over and asked him questions, lengthy questions specifically to make sure that he understood. So, with that, I am going to let that there, and then we'll come back maybe in a day or so. Oh no, I definitely won't be here tomorrow. It's Halloween. That is a special time of year. But we're gonna leave you with some of Darrell Brooks's rap. His rap was his rap name is Math Boy Fly. So if you would like to look him up online, Math Boy Fly. This is his rap name. Y'all want to find him.
Lil' B on the track, boy.
What's the business? What's the business? What's the business? Phone jumping off the chain like what's the business? I'ma pull up with the yay like what's the business? Eating lunch with the blood like what's the business? AR double drum like what's the business? 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 What's the business?
About 1,000 years, that's the business.
Catch me sliding to the trap like what's the business?
6 consecutive bids, that's the business.
Grinding trying to make a stack like what's the business? I'ma pull up on you like what's the business?
Die in prison for life, that's the business.
She gon' give it to the kid like what's the business? 30 shots in the clip like what's the business?
Killing 6, running over dozens, that's the business.
You don't gotta choose it like what's the business?
Guilty nigga, that's the business.
All my niggas on the job, what's
That's the business.
Trying to rob and you get dropped, what's the business? You a walk
In a video with the car, what's the business?
stain, what's the business?
Y'all see my face rolling over folks, that's the business.
I'ma hit your chest brain, what's the business?
That's the
We be
business.
running through a block like what's the business? 100 shots for a op like what's the business? Got
The jury says 76 times guilty, that's the business.
phone jumping off the chain like what's the
76,
business?
baby.
I'ma pull up
76.
with the yay like
That's
what's
the business.
Eating lunch with the blood like what's the business?
That's the business.
AR double drum like what's the business?
7-6
What's the
gang.
business? What's the business? What's the business?
7-6
What's the
gang.
business? What's the business? What's the business?
7-6 charges
What's the
gang.
business? What's the business? What's the business?
That's the
What's the
business.
business? What's the business? What's the business?
Beating
Bro
bitches.
say he need them pounds. What's the business?
Running over
Hit my
home.
line when I'm in town like what's the business?
Guilty.
Heard they claiming it's a drought like what's the business? Bring
Guilty.
them round them out like what's the business?
Unemployed.
Overflow like what's the business?
Baby
Killing for these
mama.
hoes like what's the business?
Don't raise your
Never leave
kids.
without that pole like what's the business? Cali out the door, what's the business?
Drive his mama
Stupid
car.
link on the cane, what's the business? I'm a guy, Charlemagne, what's the business?
Going to jail.
Pour money, that's my lane, what's the business?
Shock his
Thumbing
collar.
through a whole thing like what's the business?
Shock 'em, shock 'em.
Phone jumping off the chain like what's the business?
Shock 'em, shock
I'ma
'em.
pull up with the yay like what's the business? Eating lunch with the blood like what's the business?
Ain't getting until Jesus comes back. Oh.
What's the business? 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 What's the business?
Got arrested with a sandwich in my pocket. What's the business?
What's the business? What's the business? What's the business?
Had the key to the car. What's the business?
What's the business? What's the business? What's the business?
Kill 6 in my mama car. That's the business. All right, gang. Thank you so much for coming by so we can see what the business is. And I will get on a part 2. Be either sometime at the end of this week or early next week, but I'll be doing part 2, and we're going to cover all of his fuckery, all of the fuckery. Thank you so much for coming by. I love all of you so much. I miss you guys so much. Oh, he got more than 2 baby mamas. He got the lady, Erica Patterson. That's one baby mama. He got the one that he almost ran over. That's the one. Oh, you know what? He may have had 2 baby mamas because he ran over the baby mama, tried to run her over with the car, and they just allegedly had a baby. Now he lied and said it was a newborn, but I think the baby is like 2 or 3 or something. But thank you, Bright. I appreciate it. But yeah, he got 2 baby mamas. Yeah, I don't know how. God bless them all. Anybody who would lay down with that, God bless them. God bless. You need prayer. God bless them. Anyway, love you guys so much. Have a good evening. I will see y'all for part 2. That's coming up at some point in time. I don't even know what my intros and outros and shit is anymore. You know what? It don't even. I'm just gonna click a button.
IT Miracle.